Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing a recent decision from the Alberta Court of Appeal involving the Trudeau government's so-called No More Pipelines law. The law is formally known as the Impact Assessment Act, and it was just deemed unconstitutional by the Alberta Court of Appeal. The law had received royal assent in 2019, and it established what's called an Impact Assessment Agency. This allowed Ottawa to evaluate major projects like pipelines, mines, and interprovincial highways based on a wide range of environmental issues and social issues. Now, calling this law the No More Pipelines law sounds like it might be hyperbolic, but the reality is that this law means it's extremely unlikely that new pipelines will be built in Canada. The law lengthens and complicates the regulatory process and increases litigation risk. It's also a significant barrier to new investment in Canada. And now we have the Alberta Court of Appeal saying it is unconstitutional. Here today to explain why are three legal experts. Dwight Newman is a professor at the University of Saskatchewan School of Law and a board member at my charity, the Canadian Constitution Foundation. Brett Carlson is a lawyer with BLG who represented the Canadian Energy Pipeline Association in this case and may be representing the Canadian Constitution Foundation if this case is appealed to the Supreme Court. And Sean Sullivan is a lawyer with Osler in Calgary. Thank you all so much for joining me today. Let's start by explaining what the Impact Assessment Act is and what it does. Brett, I'll start with you. What is this law?
Sure, thanks, Christine. So the Impact Assessment Act is sort of a product of several decades of federal environmental assessment legislation. And essentially it sets out how, when, and on what terms any given project or activity might be brought under the scope of federal environmental review. So it has sort of three key features. It's got the feature of when a project will be designated under the Act and under the regulations. Then it has this planning phase of determining whether it will be subject further to the Act or further to an impact assessment. And then it has a final decision where conditions are placed on the Act and it sets out how it might be regulated moving forward.
Professor Newman, anything you want to add about how this law works that you think our viewers need to understand?
Well, I think what the Alberta Court of Appeal draws attention to is that this law applies not just to interprovincial projects, which would be squarely within federal jurisdiction, interprovincial pipelines. If the federal government takes the view they don't want any more pipelines, that's within their legislative jurisdiction.
These would be pipelines that cross provincial borders.
That's right. Yeah, I should be clear. Interprovincial pipelines would be a matter within federal jurisdiction. But this law also extends to certain designated projects that are entirely intra-provincial, so entirely within a province that would normally have been within provincial jurisdiction, and provide for regulation of those on a whole variety of bases by the federal government through its environmental assessment process. And so I'd just highlight that aspect as something quite central to the court decision.
Sean, what exactly are the types of projects that this law applies to? Is there a list of specifically what it applies to? Can that list change? How does that work?
There are actually two ways that a project can come under the Act. The first is precisely, as you say, Christine, there's a list of projects appended to a regulation. As Professor Newman mentioned, some of these are things that are classically regulated by the federal government, such as pipelines that cross a provincial border or an offshore facility. But it also includes things that are historically matters of provincial concern and jurisdiction, such as an oil sands facility or a coal mine that are wholly within a province. But interestingly about this act is it also gives the Minister of Environment and Climate Change Canada a discretion to designate a project under the federal act that otherwise is not within that list because the minister has heard either public concerns about that project or otherwise believes that there may be adverse effects in federal jurisdiction.
Yeah, I mean, that certainly adds a big layer of uncertainty, which I think has been part of the concern that the Alberta government and actually the Court of Appeal decision expressed, that this uncertainty reduces investment, especially foreign investment into these projects. We've got to go to commercial break, but when we come back, Brett, I want to talk to you about the types of impacts that are considered when a project is being considered under this act, because I know it's been kind of famous that the government actually considers how gender is impacted by, for example, an oil development project. I want to get into that because it's a little confusing, but we got to go to break, so we will be right back. Welcome back to Canadian Justice, where we're discussing a recent ruling from the Alberta Court of Appeal that the Impact Assessment Act, or the federal No More Pipelines Act, is unconstitutional. Now, we're discussing the law. Brett, in the last segment, I wanted to get into this idea of what the type of impacts that the law considers when the government's determining if a project will be approved or not. Because I think there's this sort of famous example of the government considering gender and how gender will be impacted by a mine or an oil development project. What is that all about, and what are some of the other impacts that are considered?
So I think it's helpful to separate two stages of this legislation, and there's different impacts considered at each stage. So when determining whether a project might be designated under the regulations and therefore subject to a hold, you're not allowed to do anything if you're designated, the federal government has listed out certain what's called effects within federal jurisdiction. And those effects can be the traditional sort of areas of fisheries or migratory birds or indigenous impacts. But the court really took issue with how broad this definition really was. So it allows the agency to consider things which arguably are not within federal jurisdiction, such as greenhouse gas emissions and things like that. So the area that you referenced is once the agency has determined that an impact assessment is required, it then has to apply what's called the Section 22 mandatory impacts or considerations. And the Act enumerates a list of these, one of which includes gender. Also, it includes, the need for the project, other alternatives, social, economic, health impacts and stuff like that. And essentially, it says that the agency must consider these things, and that eventually works its way into conditions that will be set and the public interest determination, and ultimately potentially the decision to go forward or not.
So a lot of different things that are considered. And this has resulted in a lot of critics saying that this is a no more pipelines law. That's kind of the nickname that it's received from a lot of people, including, I think, the Premier of Alberta. Now, as I said at the beginning, that sounds hyperbolic, but Sean, I want to know, how likely is it actually that a new pipeline could be built with this law in place?
Well, it will continue to be a project by project assessment. However, a lot of the concerns come out of the practical effects of the law. As you alluded to earlier, Christine, the fact of the matter is the Act imposes considerable uncertainty in terms of the timing, and it politicizes the assessment process as well to a considerable degree. So if you're a private sector proponent looking to invest in building a major infrastructure project that was already subject to considerable uncertainty with respect to timing in this country, this Act just exacerbates that. So it makes it increasingly unlikely that private investment capital may go into a new infrastructure project.
Dwight, so we've gone over what the law does, kind of how it works. Now let's talk about some of the objections. The Alberta government called this law a Trojan horse that brings the federal government into the provincial sphere. Can you explain that argument?
Well, so this is the element where the law ends up regulating projects that are entirely within a province and that are normally within the jurisdiction of the provinces to regulate. Matters related to natural resources are within provincial jurisdiction. There are a number of what are called heads of power, the powers of the provincial government, into which natural resource projects that are entirely within a province normally fall. And the federal government finds a way in a much larger way than previously into carrying out environmental assessments of those. And the Alberta government raised the issue, is that a Trojan horse for more? The Alberta Court of Appeal, in a 4-1 decision, says that in fact the federal government has gone too far with this law, that the law really does become about the regulation of projects that are within the province and is thus outside federal jurisdiction.
Dwight, we've only got about 30 seconds, but as I said, it comes down to the division of powers. So how did the federal government justify the law? How did they say it was within their power at the Court of Appeal?
Well, they really tried to argue that it's about cooperative federalism and that they've been able to carry out environmental assessments on the same projects as the provinces. There's more to it, but at an unnuanced level, that was their claim, that it's about cooperative federalism and it's fine for both governments to regulate at the same time.
Well, I mean, the nuances of federalism are kind of hard to get into in the 30 seconds that I gave you, Dwight, but it's a good explanation. We've got to go to commercial break, but we will be right back. Welcome back to Canadian Justice, where we're discussing a recent Court of Appeal of Alberta case that held that the Federal Impact Assessment Act, or No More Pipelines law, is unconstitutional. It all comes down to the division of powers, whether it's a federal or a federal law is intruding into provincial powers. So, Sean, this is kind of about the environment broadly. Where does the environment fit in the division of powers? Is it enumerated in sections 91 or 92 of our Constitution that sets out the powers of the federal and the provincial governments?
Well, as you can imagine, in 1867, at the time of Confederation, the environment was not in the front of mind of the founders or policymakers in the way it is today. So as a result, the environment is not one of the specifically listed matters under either Section 91 or 92. As a result of that, to link a project, to link a law to the environment, a government has to figure out which of the heads of power the environmental issue arises from. And so, for example, with respect to an interprovincial pipeline, the federal government would say the head of power is its power over interprovincial transport. In contrast, if it was a province, they would link the head of power for property and civil rights and matters of a local nature to regulate environments issues with respect to those projects.
So the Court of Appeal said that this law was unconstitutional. It was an intrusion by the federal government into provincial powers. Dwight, what more can you tell us about that decision? What were some of the important parts coming out of that?
Well, there are a few important parts. One of those is really a very technical process, or what should be a technical process, of trying to characterize what a law is about. And the Court of Appeal goes through examining the evidence on what this law does and what the purposes of this law are, to carry out this analysis of what its pith and substance is. That's a technical legal term for what the law is really about. That's going to be a contested matter, I'm sure, as things work their way up. At the same time, the court comments on a lot of really interesting things in terms of maintaining the system of federalism. I'll just highlight two very momentarily. So one of those is they give some more content to Section 92A, which is the natural resource jurisdiction power that was adjusted in 1982 as part of the 1982 amendments. That hasn't received a lot of treatment in the courts, and they've given it a really good discussion. They also highlight some other aspects that are a little bit outside the division of powers, strictly speaking. Part of the act would allow the federal government to override the decisions of Indigenous communities that are choosing to be part of natural resource projects, in effect. And the court draws attention to some of the paternalism present in that and in the approach of the federal government in this law. So there are lots of interesting things in this. It's a 750 paragraph judgment. I can't tell people to go away and read it, but if they're really interested, there's a lot there.
And even just the introduction has some really, really interesting lines in it. So, for example, the court called this law, the Impact Assessment Act, a classic example of legislative creep. Brett, what does that mean exactly?
So that's interesting. The last time this type of legislation was litigated or subject to a constitutional challenge was the Old Man River case. And the legislation at that time was very different. And there's been several amendments, incremental amendments since that point that have led to this act. And there haven't been any formal constitutional reference cases in each of those intervening amendments. And so we end up with this piece of legislation that looks quite a bit different than the original act that was subject to a challenge and in fact upheld.
And one of the other things that's interesting about it is the way the court characterizes this, Sean, as sort of about the centralizing power of the federal government. And they go into some of the history of the division of power in Canada and how it works to preserve freedoms for people in less populous or politically powerful provinces. What can you tell us about what the court said about that?
Of course, going to what is the fundamental bargain struck at Confederation, which is between issues that for reasons of need at the time of Confederation had to be dealt with by the central government, and issues where there was good reason to have diversity within local views and the differences between provinces. In this case, one of those differences is a matter of local economy, and that's the importance of natural resources to the province of Alberta and the amendments that came in with Section 92A to the Constitution. So the court goes at great length to discuss the history of that, the importance of the province of Alberta of natural resources, and all of both the tone and content of the decision is based on that, and based on what historically has been seen in Alberta as centralizing tendencies to at times take power away from the province with respect to natural resources.
We've got to go to commercial break, but we will be right back to continue the conversation. Welcome back to Canadian Justice, where we're discussing the recent finding by the Alberta Court of Appeal that the Impact Assessment Act is unconstitutional. Dwight, the issue of natural resource development is a really sensitive one for the prairie provinces historically, and the Alberta Court of Appeal made a note of that in this decision. So what makes this issue of resource development so significant for the West, both practically, but also as a part of Canada's constitutional and legal history?
So going to the history first, the prairie provinces did not have control over their own natural resources for the first several decades after being admitted as provinces, unlike any other provinces, and they were admitted later as provinces. So for a long time, the natural resources of the prairie provinces were used for the benefit of central Canada very directly. And then there were adjustments made to that in the early 20th century, several decades in. Then the prairie provinces hit this period where they were doing really well in the 70s, and the Supreme Court stepped in some ways that took jurisdiction away. That got changed back in 82. So there's been a long battle over these issues, and at various times, there's just been a sense in the prairies that this is one of the areas that's very significant to the economy of the prairie provinces, that's not well understood or well treated by other parts of the country, even though the prairie provinces are contributing significantly to Canada through this and have the potential to contribute much more even than they already do, but they're constantly interfered with from their perspective. And I think there's a lot of sensitivity around this out of that history and out of present day circumstances as well.
Sean, this case, as we've discussed, is the court perceived it sort of as the centralizing power of the federal government. If the federal government wants to centralize power in this policy realm, the environment and beyond, and if they're permitted, is there a concern that they could try the same thing in other policy realms and for healthcare, for example? And should we be concerned about that?
One of the primary issues that arises in these cases is that the federal government has some extremely broadly worded powers under the Constitution. And one of those that almost invariably relies on in cases regarding the environment is a power over peace, order, and good government. In essence, the federal government says we have a matter of national concern, therefore we will legislate nationally, notwithstanding there's no specific power dealing with it. And that's what we've had in this case. We had that in the carbon tax case. It comes up in healthcare cases. So there's always a concern that if that power is expanded, what are its limits?
Now, Brett, this case is a reference. It's called an advisory opinion. The court found that the law was unconstitutional, but what does that mean for the law in practice? Is the law still in force? Does this go to the Supreme Court? And then what might happen?
Yeah, so technically a reference case, as you said, is an advisory opinion. The act itself is not struck from the books. It is still in force. And practically, there might be some implications. Project proponents may look at this and see some uncertainty and maybe perhaps put some projects on ice for the time being. But those aren't strictly legal effects. And then to answer your last question, that's correct. This has been appealed formally. So the notice has been filed, I believe, a few weeks ago, and we're now in the process where interveners will start to apply for leave. FACTA will be submitted, and it will probably be heard sometime in late 2022 or early 2023.
And an intervener for our viewers is a person, an organization or a group that does not have a direct interest in the litigation, but can contribute to the development of the law. And the organization that I work for, the Canadian Constitution Foundation, is considering applying for leave to intervene in this case. It has really important implications for federalism in Canada, especially division of powers and peace, order, and good government. So we are working with Brett on that potential leave application, and I'm really excited about that. We'll have more to tell you about that soon. That's all the time that we have today for discussing this. I want to thank all three of you for coming on to discuss it with me.
Thank you.
Pleasure. Thank you.
We've heard today about the decision by the Alberta Court of Appeal that held that the Trudeau government's No More Pipelines law is unconstitutional. While the law remains in force, the case will now head to the Supreme Court for final determination. What do you think of the law, of its impacts on Alberta, and the questions of whether this law treads unjustifiably into provincial jurisdiction? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.